Okay. Do we need a minute or is everybody good and settled? Okay. I think I have a mic. We see. Okay, if I have to, I'll just yell. I usually just yell. Okay, so here we are at divorce and the special needs child. And I, first of all, just wanted to thank Bobby for letting me come. I'm so excited to be here, especially in person. I'm very tired of Zoom, and I'm so excited that I'm in a room with people. And I'm so grateful to all of you who made it here in person. Yay for in person. Yay. So my name is Kim Martin, and I'm an attorney in Atlanta at a firm called Nadler Biernath, and my entire practice is devoted to special needs work. And before I tell you what I'm going to talk about, I'm going to just briefly tell you what I'm not going to talk about. One of the things I am not going to talk about is all the material that's probably like the first half of your handout, because it is basic introductory material about what is a special needs trust and what are the different kinds and how do you qualify for SSI? And nobody in this room needs me to tell you that stuff. So if you want a really general overview of that type of stuff, you can take a look at your handouts, but I'm not going to talk about it. And I am also not going to talk about divorce when there is a special needs party. That's a different situation and it requires different types of planning, and we just don't have time to talk about it. So I am not going to. But I am going to talk about specifically divorce when there is a special needs child in the mix. I was really excited when Bobby asked me to come and talk at Stetson, and I'm especially excited to talk about this particular subject because it's becoming a growing part of my own special needs practice. We did a brainstorming phone call a few months ago, and Bobby asked me how I got interested in this work. And I told her, I am a divorced mom of a special needs child. So I know there's a huge need for lawyers who do this kind of work. The nice thing about being one of those lawyers is that once you've educated the divorce lawyers, they will spot the issues and they'll just call you when they need you. So my goal today is to tell you what to do when you get that call. So first, talking points. So these are the things that I am going to try to cover today. And the first is, what is the problem? Why do we even care if there's a special needs child in a divorce situation? And once we've made that clear, then the next issue is, what do we do about it? And then finally, I think probably the most useful part of this talk is the last third of it, which is how do you issue spot when you're reviewing a settlement agreement? And how do you do damage control when you can't have your best case scenario? And often in divorce situations, you can't have your best case scenario because everybody is mad and angry and they are not their best selves and they're out of money and they're exhausted. So sometimes you just have to kind of do damage control, and sometimes that's the best you can do. So the first thing we need to educate ourselves about is the exact terminology that's used in the POMs that affects the situation where we've got child support in particular being paid for the benefit of a child that has special needs. And the POMs actually defines child as a person who's under age 18, or in some cases under age 22. All of our kids are very likely to qualify for additional services through the public school system until they reach age 22. So sometimes a child, as far as the POMs is concerned, is somebody who's under age 22 who is still getting education, either designed to just give them academic education or voc rehab type education that's designed to prepare them to do a job. So that person is considered a child as long as they are not married and not the head of a household. So an adult child, obviously, is someone who no longer fits the definition of child. And child support is a payment that's intended to be for the food and shelter costs of a child. And it's child support, whether it's paid in cash or in kind. It's child support, even if we don't call it child support. We can't get around this whole issue by calling it something that's not child support. If it's paid for the support of the child, it's child support. So the POMS has this very old-fashioned way of describing the parents in this situation, and they define the absent parent as the parent who's paying child support and who doesn't have the greatest amount of custody of the child. And the child, the parent is determined to be an absent parent if the child is not living in that person's household as of the first day of a given month. And the custodial parent is, of course, the parent that has primary custody of the child. And a child support arrearage payment is just a payment that's overdue. And if there's an arrearage due and it gets paid, it still counts as child support, and we have the same issues happening that we would have if it was just a regular child support payment that's getting paid on time. So there are certain ages in divorce land, and some of them also affect special needs land, and some of them don't have anything to do with each other. So age 18 is a really huge, significant age in both cases. Age 18, of course, in special needs land is when most of our kids will qualify for SSI, because age 18 is when the child becomes a household of one for benefits purposes. So that's a big deal. And in divorce situations, that is potentially when child support payments will stop being payable, but there are lots of exceptions to that rule. I put age 20 up here because in some cases that's relevant in the context of a divorce. Specifically in my home state of Georgia, Georgia law makes absolutely no provision for additional time for child support for a disabled child. They just don't recognize any special factors there at all. So under Georgia law, the oldest age that a court order can require child support to be paid is age 20. And that's if the child is still in school, not married, the usual kind of thing. In California, by contrast, there are no limits on how long a court can order child support for if there's a disabled child. And then age 22 is the oldest age for the child to be considered a child under the POMS. So the problem that we have to deal with first is the child support issue. There are others that I will get to, but child support under the POMS that's paid for the benefit of a child who meets that POMS definition of child counts as the child's unearned income, regardless of who it's paid to. So if we have child support paid for the benefit of a child, then we exclude the first third of the payment. We also do a $20 disregard for the personal allowance, and then the remainder offsets SSI dollar for dollar. I know you can all read, I'm not gonna walk you through this example, but if we have that situation when we've got our example of paying $900 a month in child support, we still end up with a little child support because we've got that 1/3 disregard, unless we have a child whose paying parent is not an absent parent. So if the paying parent is the parent whose household the child lives in on the first day of a given month, then we don't get that 1/3 disregard. All we do is disregard the $20 and all of the rest of the child support, in this case, $880 will offset SSI dollar for dollar. It'll wipe SSI out completely. And in a lot of states, like mine, if you lose SSI, you also lose Medicaid. So support payments for an adult child, which means over age 22 or potentially over age 18 or somewhere in between, just depending on the facts. Again, child support that's paid for the benefit of an adult child still counts as unearned income to the child. We never get the 1/3 disregard once we have an adult child. So just like in my previous example, we disregard $20, all the rest of it applies to wipe out SSI and in many cases, Medicaid. So what do we do about this? These are all the terrible solutions that I will tell you about because I have seen people do them and they are all horrible. So your job, if somebody proposes any of these solutions, is to educate them so that they don't do them. And the first terrible solution is let the parents just say, well, never mind, we don't care, we just won't get SSI. That's a horrible plan, in part because the parents are then subsidizing $794 a month, plus the cost of, various types of medical care that the child could otherwise be getting if they would just do their planning properly. There are also long-term problems with this because we really want our child to be, labeled, unfortunately, as disabled by Social Security before the age of 22, so that someday when one of the parents either dies or retires or becomes disabled themselves, that child will go from SSI to SSDI. So we don't really want to just kind of wave away the importance of getting SSI. There are a lot of good reasons why we want those SSI payments to be made. Another terrible plan is to make sure that the settlement agreement provides that child support just stops at age 18, because then the child can get SSI. Well, I mean, that's not as terrible a plan, but it's still a fairly terrible plan, because then you've got, resources that are left on the table that could be available to pay for the care of this child, and they're not getting paid. I have had people try having the settlement agreement say, well, this child doesn't get any child support, but these other two kids get lots of child support. That's not going to work. Medicaid is not stupid. They're going to see the settlement agreement. They're going to ask for it. If you have a child who's on Katie Beckett or on, and whenever you begin to apply for benefits, they ask for a copy of the settlement agreement. So one of the requirements is that child support has to be reasonable. You can't just make up a number or say the special needs child doesn't get anything, so there's no child support, problem solved. You also can't have the settlement agreement require that the paying parent fund an ABLE account. This was sort of a gray area for a while. For a couple years after ABLE accounts came into existence, Section 529A of the Internal Revenue Code, which is the code section that creates ABLE accounts, doesn't address this at all. And it took, I think, a year or two before Social Security addressed it. So we weren't really sure what would happen for a while if you had child support payments made to an ABLE account, but Social Security has weighed in on that issue definitively. And while the cash in the ABLE account is definitely an exempt resource for purposes of the means test, if you make child support payments to an ABLE account, it still counts as income to the child. So you just can't do it. It won't work. And then the last terrible plan is to have the settlement agreement require the parents to fund a third-party special needs trust. A lot of parents love this idea when you tell them the difference between first-party and a third-party trust because they don't like the Medicaid payback, but you can't do it. It's not going to work. You just cannot do it. So these are less terrible ideas that will work if nobody will agree to the ultimate perfect solution that we'll get to next. So modified alimony is a thing that you can do in some states. This is going to be state specific, so you're going to probably want to work with your divorce attorneys to figure out how likely it is that this is a good plan. It has zero effect on SSI, which is nice. In a lot of states like Georgia, if there are special circumstances, then the court can order either additional alimony or a longer period for alimony. One of those special circumstances would be if there's a custodial parent that's going to have a lesser ability to work because they have really serious childcare duties. So it's possible to have modified alimony put in place instead of additional child support that you then have to figure out how to deal with. Another option that's okay but not great is to have the settlement agreement require the paying parent to just pay directly the child's food and shelter costs. So that's not income, but of course it's going to trigger in-kind support and maintenance issues, and SSI will be reduced by a third. So that's better than wiping out SSI altogether, but it's not the best solution, and it's so avoidable, I don't think it's a good plan. And then another kind of not great plan is to have the paying parent require, or to have the agreement require the paying parents to pay for something other than food and shelter costs. So it might say the paying parent will pay for private school tuition. The paying parent will pay for summer camp, whatever. That also has no effect on SSI, so that's nice. But the custodial parent gets no help with probably the most expensive cost of taking care of this child, and that's food and shelter costs. And we also have to deal with what happens if these expenses go away or go up. So if that's going to be part of the settlement agreement, there needs to be a really comprehensive plan for all the different contingencies that could affect the way that would work. So this is my favorite solution. This is the one that, if you can get everyone to agree to it, is the perfect way to resolve the issue of child support. And that is to have the settlement agreement require the paying parent to pay their child support payments to a first-party special needs trust. And that can be either a D4A trust, which is a private trust, or a D4C trust, which is a pooled trust. In either case, if those payments are made and the settlement agreement is drafted properly, then the child support payments do not count as income for the child, so they can get their full SSI. The settlement agreement has to be worded properly, so this has to be part of a court order. The parents can't just agree to do it. Or if it's not part of a court order, later the parent who's receiving the payments could do an irrevocable assignment. If you do my money laundering trick that we're going to talk about later, you can even use the D4A money to pay for food and shelter, and there isn't really any penalty for doing that. So I remember when I graduated from law school and I got my first job at this big tax planning firm that did lots of estate planning, and they said, we need you to draft a will. And I sat there and I had this quiet little panic attack because I realized I had never actually seen a will, despite the fact that I had practically majored in trust and estates, if you can do such a thing, in law school. And I kind of felt the same way when the first divorce lawyer sent me their settlement agreement and said, well, what should I do? And I was like, I don't know, despite the fact that I'd been giving them all this wonderful advice and I sounded so much like I knew what I was talking about. So this is a little thing on issue spotting. So the child support issue is a big deal, but it's also pretty easy to fix. But there are other things that you should look for in the settlement agreement when you're reviewing it. And one of them, kind of surprisingly, I guess, is alimony. Alimony is not your job. It's not your problem. You are not looking out for the person who may or may not be getting alimony. But because of the fact that modified alimony is one of our kind of okay solutions to the child support issue, you should at least read the section on alimony. And if the parent that would otherwise receive alimony is waiving alimony, you may want to just kind of flag that and write a little note to the divorce lawyer and say, you might want to keep this in your back pocket because we may not want to waive alimony. And that's not your call, but it's a way to educate your family lawyer about the way all these issues work together. Life insurance is a super big deal. Child support, even though we've spent lots of time talking about child support, is so fixable, but life insurance is actually a lot more problematic than child support because it's fairly easy to talk the parties into agreeing, okay, we're going to pay a few $1,000s a month into this first party trust. And we don't like the fact that there's a Medicaid payback, but realistically, we're going to put the money in and then we're going to take it right back out again and spend it because we need it to take care of the child. That's what it's for. So people usually kind of come to terms with that eventually after you explain it, and they kind of go, all right, okay, fine, we'll use the first party trust to hold child support. They are much less willing to name a first party trust to hold $1 million in life insurance sometime in the future when everybody is old and there's less time to spend it. So many settlement agreements have a provision that say either one party or sometimes both parties have to maintain a life insurance policy on their life, and it has to exist either until child support is no longer payable or sometimes forever. I mean, if you have a special needs child, it's good planning to have not a term life insurance policy, but a permanent life insurance policy, because there is a need that never goes away, divorce or no divorce, child support or no child support. It's just good estate planning to have a permanent life insurance policy. So If the parties absolutely refuse to trust each other to the extent that they will not agree to anything except you have to have this policy and it has to be payable for the benefit of this child, then you are stuck with a first party special needs trust. If the parties are willing to be at the other extreme, which almost never happens, and say, I know that I can trust you to take care of your child no matter what. Don't worry about it. I know that you're going to maintain life insurance. Then you can use a third party trust, no problem. Divorce lawyers hate that. The parties are usually not there anyway in their own heads, but even if they start out there, they don't end up there because both of the lawyers are like, no, that's a terrible plan. We need some kind of a rule or a requirement or something that holds somebody accountable for this life insurance. So one thing that I have suggested before, and this is where, again, you're working closely with the divorce attorney who is moving around all the moving parts, is my favorite way to do this is to have a permanent life insurance policy in place on one party, have the other party be the owner of the policy, with no restrictions on what they can do with it. This is a tricky thing to make happen because one or the other of the parties is not going to like it. But if we can have one party own the policy and be free to name anybody they want as the beneficiary, that means they can name themselves, they can name the pool boy, they can name anybody they want to, but that means that they are free to name a third party special needs trust as the beneficiary of the life insurance policy. And then there are also issues that are kind of really more the divorce attorney's problem than your problem, like who's going to pay the premiums? What do we do if nobody pays the premiums? You know, that's something that the divorce attorney is probably going to want to address. But life insurance is kind of this little hidden time bomb in the settlement agreement that you should pay attention to and make sure that you don't have a provision that says that one party will maintain a policy for the benefit of a child, because that makes it first party money, and that is bad. So the last thing that is easily overlooked that you shouldn't overlook is provisions for medical insurance. It's also very common to have one party be required to maintain medical insurance and cover all of the kids, including the special needs child. And that's not a problem, but then the agreement often will go on to say that one party or both parties, somebody in the agreement is required to pay for any uncovered medical expenses. So keep in mind that Medicaid is a payer of last resort. So if Medicaid sees that provision, they are going to say, oh, well, I guess we don't have to pay for speech and OT anymore because you're required to pay for everything that isn't covered by somebody else. And we're a payer of last resort. So enjoy paying for speech and OT. So if you see a provision like that, just make sure that you reword the provision to say neither one of the parties is responsible to pay for medical expenses that would otherwise be covered by any local, state, or federal agency, including but not limited to Medicaid. Because we don't want to, take all the teeth out of the Katie Beckett waiver or later the Medicaid that the child would get with SSI. So these are all things that I learned by doing them wrong, and I'm telling you about them in the hope that you will not do them wrong. The very first thing is make sure that when you're working with a divorce attorney and they say, I'll send you the draft and you can tell me what you think about the wording, don't let them send you the section on child support. Make sure you get a copy of the entire agreement and make sure you get it in Word or in some format that allows you to type all over it, because that's the best, most efficient way for you to give feedback on the document. So when I get the agreement in Word, I will typically just save it as another document that says, KCM notes on agreement or something. And I will put my additions, language that I think should be added, in red. I will put notes to the attorney in green. So I might reword something in a way that doesn't seem like it matters, but it does matter. So I'll put my new wording in red, and then I'll say in green, this exact wording is really important. This is what the POM says. We have to word it this way. And then if I eliminate anything, I will highlight it and do the strike through thing so that they can see, here it is in your draft, but I'm telling you, I think you should take this out. And then I save the whole thing and I send it back to the divorce attorney. And, you know, I'm not in charge of the settlement agreement. They just hired me to tell them what I think. So that's a way that I can give them my 2 cents without, you know, manhandling their settlement agreement in a way that's going to upset them. But it's a very thorough way for me to present my thoughts about what they should do. So also, inevitably, if this goes the way we would like it to go, there's going to be a first party special needs trust. And if it's a D4A trust, so a private trust, make sure that the divorce attorney has the trust executed before the settlement agreement. Make sure that they refer to the trust by name. Don't just say a special needs trust. The blah-de-blah special needs trust signed on whatever date. And make sure that you attach the trust to the settlement agreement and incorporate it by reference so that it becomes part of the court order. That will save so much fighting 3 years later when the parties have kind of recovered from the initial divorce and they're looking for something else to fight about. All the terms are done. We know who the trustee is. We know who the successor trustee is. There's not that much to decide really with a D4A trust. We just don't have that many options. But you know, it's just much better if you don't give the parties anything to fight about. Once the settlement agreement is done, everything should be done. So make sure that you don't have the divorce attorney put in something like these first 2 examples, like the paying party will pay child support for the benefit of Johnny to a special needs trust, or they agree to a trust to hold child support payments for Johnny. So put in the wording yourself in red so that you know that it's been worded properly. Beginning on the day Johnny reaches age 18, the paying party will pay all child support payments for the benefit of Johnny to the then serving trustee of the Johnny Smith Self-Settled Special Needs Trust, signed October 14th, 2021. A copy of said trust is attached hereto as Exhibit A and is hereby incorporated by reference into this agreement. So there's no question about anything. There's no fighting later. It's done. It's part of a court order, which is what we have to do under the POMS. And it also just eliminates a lot of arguing. These are more things I learned the hard way. Don't tell the drafting attorney, I recommend that you do this. Put the language in there. They have never heard of the POMS. They don't want to read the POMS. They don't know what the POMS is. So if there's specific wording that needs to be there for some particular reason, just put it in there in red or whatever code it is that you decide to use when you're marking up the settlement agreement. Also, you know, a lot of times we don't get our best case scenario. So if you've got your favorite choice, but you know that maybe the favorite choice is not going to happen, then give different options. So say, you know, this is what I would like to see this, you know, how I would like to see this go. If that's not going to work because the parties won't agree to it, or because we have to trade this for something else that's part of this big giant divorce that's full of moving parts, then maybe you could try option B. Option B is my second favorite option, and explain why. Also, stay in your lane. It is not your job to worry about who gets the beach house. It is not your job to tell your client what you think about the divorce attorney's handling of the entire issue. You are there to help figure out the best way to use all the resources that there are to take care of the special needs child. That's what you're supposed to be doing. It's kind of relaxing once you realize that, and just stick with that. Also, know who your client is. This is really important, and if you possibly can, have one of the parties hire you, and then do not talk to the other party. I have had a couple of parents want to hire me together, and I honestly, it goes so badly that I don't know that I would ever do it again, because you have to be so careful to just be completely neutral and confine everything you say to sort of, here's the way this will work. Here's what I think you should do because of these reasons that will help you take care of your child. And some of the benefit that you bring to the table is if you work for one party, not only can you give them that information, but you can help them strategize. Here's the stuff you should care about. Here's the stuff that doesn't matter. If he wants this, let him have it. That you can't do that if you're working for both parties. So to me, it's much easier to be very clear in your own head about, I work for this person and I don't work for anybody else. Also, know your state's child support rules. You're not going to know them as well as a family lawyer will know them, but it's going to help you to suggest ways to structure the settlement agreement if you just at least are familiar with the child support rules in your state. Sometimes the most difficult person that you have to deal with when you're doing this kind of work is your client, because they are stressed out and they're terrified and they don't know what they're going to do and they don't listen to you for one reason or another. And so when that happens, it's really important for you to just educate your client. Here are some little scenarios, all of which I've had happen. The parties are sick of paying lawyers. They refuse to pay for a D4A trust. And that's easily solved because you can just suggest to them, you can use a D4C trust. It's not completely free. You have to join it, but it's less expensive than paying for a private D4A trust. That also eliminates the issue of, who's going to be the trustee, because nobody gets to decide who the trustee is. You get one trustee, that's it. That just is one more thing that they can't possibly fight about. That's the next one, is sometimes the paying parent doesn't like the idea of funding a D4A trust because generally the custodial parent is the trustee. And they don't want to put all this money into a trust where the custodial parent is the trustee. I mean, to me, that's something that you can educate away as a problem, because the alternative is we just give the money to the custodial parent and let them do whatever they want with it. So it's really more restrictive to have that money getting paid to a trust that's being subject to oversight by Medicaid and subject to fiduciary rules than it is to just pay the child support to the custodial parent. The custodial parent hates the idea of the D4A because they don't like the Medicaid oversight rules. They don't want to have to do annual accountings. They don't want to have to keep track of what they're spending money on. They just want to get their child support and pay the mortgage. And they can't. Well, they can if they do money laundering, but we're not there yet. So, some of these are legitimate things to worry about. They don't like the sole benefit rule because, they want to put all the money into a big giant pot and use it to manage the household and take care of all the kids. And that's perfectly understandable. But, if the alternative is that we're going to either lose SSI or have it reduced potentially dramatically, the D4A trust is sometimes it's the best solution that we have. And then the last one is both parents ignore everything that you've said to them. They go ahead and get a divorce. They don't address this issue at all. And then later, one of the parents comes back to you and says, how do we fix this? So remember, we can have child support payments ordered under a court order, so under the settlement agreement, to be paid to the D4A trust. But if it's too late to do that, the other thing that we can do is we can have the parent who's receiving those payments do an irrevocable assignment to a D4A trust or a D4C trust. So these are the money laundering opportunities. If we've got money going into the D4A trust and the parent wants to use it to fix the roof or, pay the mortgage or repair the plumbing or do something else that they're not allowed to do, well, they can't do that because of the sole benefit rule. But what they can do is charge their child rent. So I have a very basic little 2-page room and board agreement that I give to clients all the time. It's not a big deal really, and they probably should be charging the child rent anyway for other reasons. So, you can suggest to them, you can't use this money to fix the roof, but you can charge rent. And once you get paid rent, it's your money and you can do whatever you want to with it. Another thing that comes up often as our kids get older is the custodial parent wants to move their child into a private facility and they want to use D4A money to do that. They want to pay the rent essentially using D4A money because private facilities cost way more than $794 a month. So the money has to come from somewhere. The obvious place to all of us, at least, for it to come from is an ABLE account. So when I am drafting a D4A trust, I always have a provision that allows the trustee at the trustee's discretion to fund an ABLE account. So the child support goes into the D4A trust. The trustee, who is probably the custodial parent, opens an ABLE account. They put the money in the ABLE account. They take the money out of the ABLE account and they pay for the private facility. So we have no in-kind support and maintenance. We have no income issues that offset SSI. So this is a lot of hoops to jump through and it's kind of a pain, but it's the most efficient way to use all the resources. And finally, people ask me this all the time, can we ever use a third-party trust in a settlement agreement? No, we can't. We cannot, but we can use a third-party trust outside of the settlement agreement. And sometimes if people are willing to, we can use it with concurrently with the settlement agreement. So in my example of the life insurance, if we have one party owning the policy and just freely deciding to fund a third-party trust, that's no problem. If the parties are contemplating divorce, but they both agree that they want to take care of their special needs child and they create either a joint third-party special needs trust, or maybe one of them just creates the trust and says, look, let me just put some money in here, we'll make it irrevocable, and we'll ignore that money for settlement purposes. If everybody agrees to that, it's totally fine. We just can't have the settlement agreement require money to be paid into a third-party special needs trust. So that's everything I have. I went as quickly as I could because I have this lovely, I'm at 0. Look at that. So I left a little bit of time for questions and people are welcome to ask questions. Did you have a question?
Do you ever suggest in the settlement agreement that you address the adult dependent child on Social Security? So there's a formula perhaps that it would reduce the child support to prevent the need to have a modification?
So are you saying when the child goes on SSI, then the child support amount gets adjusted?
No, I'm saying when the child goes under an adult dependent child under Social Security for under the SSDI. Right, that under that you have a reduction in the child support, like a formula.
I have never done that. That's more of a divorce attorney decision than a me decision. I mean, that's certainly something that could happen. But I mean, it's once you're on SSDI, I mean, that's typically going to be more money than SSI. So what you're saying is we would then address the child support amount by reducing it concurrently with the SSDI amount.
I believe there's an opportunity for the advocate on special needs to be able to advise the divorce attorney to have formulas in that agreement to prevent the need to have to go back and modify the agreement later.
You certainly could do that.
And the other issue I was curious about, if you bumped across both rehab with the WIPA, with the workforce intervention, where the kids are starting to work, and they're disregarding that income, but how does that play into support issues? And have you seen any agreements address that?
I have not seen any agreements address that. So you're saying the child earning income would potentially reduce child support that gets paid?
Absolutely.
I have never had anybody worry about that issue. Most of the time that the amount that's earned is not a whole lot of money. That is certainly something that could be addressed if anybody was looking that far down the road and wanted to address it. The trouble with that is that usually the earnings are not a consistent amount of money. You know, if you've got somebody who's working 7 to 20 hours a week and they're making $13 an hour, I mean, we don't know how much they're going to earn in a given month. So there would need to be a formula instead of a.
But if they did, they'd end up on Social Security disability far before their parents would get them that. And so I'm saying there are ways to work formulistically I was just curious if anyone has focused attention in that area.
Usually my families they've got younger kids, and this is probably a huge issue in a state like California where child support can go on forever. In Georgia, unless the parties agree to it, child support ends at age 20. A court is not allowed to order child support beyond age 20. So you'd have to have a separate private agreement between the parties that became part of the settlement agreement for child support to go on for that long. So if you live in a state where child support is more generous for a disabled child, that's probably a really important issue. Did you have a question?
I have a mom who had a back child support order against a very absent dad and got an order, a Woodrow transferring part of his 401k, which is then an exempt resource because it's not deemed to the child. Should she have reported that as receipt of?
If it's a child support payment as opposed to a property settlement payment, then that's a child support arrearage payment, and that should offset SSI dollar for dollar. But that's actually not, that wouldn't be a horrible outcome, because I would think if it's all getting paid in one sum at one time, it might wipe out SSI in a given month, but not forever.
So even though it's her Woodrow and an exempt resource.
Well, if it's hers, then it's not child support.
Well, it's a back child support order, but the result of it was the transfer to her of this Woodrow. That's what the court did.
That's interesting. I'm not sure how that would work. Maybe if we can talk about that at the cocktail party, because I'm going to have to think about that. It doesn't make any sense to me that child support would go into the mother's name.
But because she provided the support.
So this was like reimbursing the mother.
So what
To me, that still sounds like child support.
it sounds like it's child support that was payable to the mother while the child was a minor. And so the arrears, the quadro, that's how we say it in Texas, would have made it payable to mom because that payment would have been payable to her.
But if we call it child support I've never had, oh, sorry, I shouldn't talk with my hands. I have never had that specific thing come up, but to me, that just sounds like child support. But if it's all paid at one time, I mean, that's not horrible. So we wipe out $794 in a given month and then we're done. But I'm guessing, I don't know. That's a great question. I don't understand why they gave her the money that way. Maybe there wasn't anything else.
Well, the dad's an Indian, so he couldn't find.
Ha. Life is messy. I think I'm at 0. Am I at 0 for real?
5 minutes.
I have 5 minutes. I have 5 minutes. Does anybody else have any questions?
I don't have a question, but my advice on this is to get paid upfront in full.
There you go.
And guess what? They'll come up with it. They might not, if it's like the last.
Well, that's always good advice. Did you have a question?
Yeah, I do a lot of part of that. First cases, so is there anything you would want to party that might put in the report in regards to questions you have?
I think one important thing is if you can give the court a really thorough, accurate summary of what the child's deal is as far as benefits is concerned. So if you've got, if you've got an 8-year-old and they're on Katie Beckett, let's say, just saying, this is probably a child who's going to qualify for SSI someday, and this is potentially going to be an issue, and the court needs to, if no one else is looking into it, the court needs to look into what's going to happen when this child turns 18 and becomes a household of one. I mean, at least raise the issue. And if you've got an older child who's already on benefits, say, they're getting this much in SSI, they're on Medicaid, the court should be aware that just plain old child support payments could potentially wipe out the ability to get SSI. So I think if you raise the issue at the very least and give a really thorough accounting of what the child is on, that would be really helpful for the court. And a lot of times, even parents don't know what their child is on sometimes. It's amazing how often they don't have a clue whether their child is on SSI or SSDI. Does anybody else have any questions? I think we're timing this perfectly. Yes, I have 2 minutes. 2 minutes. Okay, thank you.